another unanimous ruling from the Supreme Court. Supreme Court has just issued a major ruling.
Major Supreme Court ruling.
Major ruling involving the Second Amendment.
The Supreme Court will be taking up a gun rights case.
Members of the Senate are focusing on gun rights.
9 Supreme Court justices just did something that almost never happens anymore. They agreed unanimously on a decision that fundamentally changes how federal law enforcement can operate in America. Not 8-1, not 7-2, 9-0. When the Supreme Court speaks with that kind of unified voice, federal agencies listen, and right now, they're panicking. This ruling didn't make headlines the way some gun rights cases do, but behind closed doors at the FBI, ATF, DEA, and U.S. Marshals Service, emergency meetings are happening. Legal teams are reviewing decades of operational procedures. Internal guidance documents are being rewritten in real time. And perhaps most telling, agencies are desperately lobbying Congress to legislate their way out of what this decision just opened up. What happened? The Supreme Court just cracked the immunity shield that's protected federal agents from accountability for wrong address raids for nearly 8 decades. And the implications for gun owners specifically are massive, because firearm seizures during mistaken raids just became legally vulnerable in ways they've never been before. The next 12 months will determine whether this becomes a genuine shield for citizens or just another legal footnote that agencies find creative ways to ignore. Here's what you need to understand about what just changed, what federal agencies are doing right now to adapt, and why every firearms owner in America should be paying very close attention. For 78 years, federal agents have operated under legal protections that make them nearly impossible to sue successfully, even when they raid the wrong house, terrorize innocent families, and confiscate property from people who did nothing wrong. The system works through 2 interconnected mechanisms that create what lawyers call a double-layer immunity shield. First, there's the Federal Tort Claims Act, passed in 1946, which theoretically allows citizens to sue the government for wrongful actions. Sounds reasonable, right? Except the act came loaded with exceptions that federal agencies have exploited for nearly 8 decades. These exceptions were ostensibly designed to protect legitimate government functions from frivolous lawsuits, but they morphed into blanket shields protecting incompetence, recklessness, and outright misconduct. Second, there's qualified immunity doctrine, which works alongside the Tort Claims Act to create a nearly impenetrable barrier to accountability. Federal agents successfully argued for years that they deserve broader immunity than state police because they're enforcing federal laws, a circular logic that essentially says the more powerful the government agency, the less accountable its agents should be to the people they serve. This created a legal reality where approximately 92% of wrong address raid lawsuits against federal agencies got dismissed at early stages based purely on immunity claims. Victims never got to present evidence about what actually happened. They never got to show whether agents followed proper procedures. Courts simply accepted agency arguments that immunity applied and threw out cases before they even started. The Supreme Court's unanimous decision doesn't eliminate these protections entirely, but it creates the first significant crack in this immunity wall in over a generation. The court ruled that federal agencies can't stack immunity exceptions to avoid all accountability, that lower courts must actually examine whether agents followed proper procedures and acted reasonably before granting immunity. That might sound like a technical legal distinction, but it's genuinely revolutionary in practice. Within 48 hours of the Supreme Court's decision dropping, every major federal law enforcement agency issued internal guidance documents instructing agents on adjusting operational procedures. This wasn't public announcement. These were internal communications that sources within federal law enforcement described as near-panic responses to a ruling that caught agencies completely off guard. The FBI, ATF, DEA, and U.S. Marshals Service held emergency briefings with legal teams to assess potential liability exposure from past raids that might now be challenged under the new framework. And here's what has agency directors losing sleep. Hundreds of previously dismissed cases could potentially be reopened if victims can demonstrate that immunity exceptions were improperly applied. The Department of Justice quietly assembled a task force focused on reviewing raid procedures and use of force protocols to minimize liability under this new legal landscape. According to sources who spoke on condition of anonymity, the primary concern isn't just future raids, it's the potential avalanche of past cases that might be revived. Agencies are particularly worried about cases involving gun owners where excessive force was used, wrong addresses were targeted, or firearms were seized and never returned, even after mistakes became obvious. Federal agencies are also actively lobbying Congress behind closed doors to pass legislation restoring broader immunity protections or creating new exceptions to the Federal Tort Claims Act. Agency directors argue publicly that this Supreme Court decision will have a chilling effect on law enforcement operations. But what they're actually worried about is accountability for systemic problems that have plagued federal raids for years. inadequate training, poor intelligence verification, pressure to meet raid quotas, and patterns of constitutional violations that internal reviews have documented but kept hidden from public scrutiny. Before this ruling, the legal landscape for wrong address raid victims was bleak. File a lawsuit, watch it get dismissed on immunity grounds before discovery even begins, and go home with nothing. No compensation, no returned property, no accountability, and no answers. The practical impact of the Supreme Court's decision fundamentally changes this dynamic by requiring courts to examine whether agents acted reasonably and followed established protocols before granting immunity. What does that mean in practice? It means federal agencies will now face discovery in vastly more cases, forcing them to produce internal documents, training materials, briefing notes, and communications showing how raid decisions were actually made. This discovery process terrifies agencies because it often reveals systemic problems they desperately want hidden. Things like inadequate address verification procedures that everyone internally knows are insufficient, pressure from supervisors to meet operational quotas that incentivize quantity over accuracy, and documented patterns of constitutional violations that agencies have internally acknowledged but never fixed. When these documents become public through litigation, they create evidence for future cases and generate political pressure on agencies to implement actual reforms. For gun owners specifically, this decision creates entirely new opportunities to challenge firearms confiscations during wrong address raids. Previously, when federal agents raided the wrong home, seized firearms from innocent people, and then held those weapons for months or years during investigation, victims had virtually no recourse. Agencies argued they had discretionary authority to hold weapons during investigations and couldn't be sued for seizures because those decisions fell under immunity protections. Under the Supreme Court's narrower interpretation of when immunity applies, victims can now potentially sue not just for property return, but for compensation for deprivation of their Second Amendment rights during wrongful seizures. That's a genuinely new legal theory that didn't exist before this ruling. The decision also opens doors for emergency injunctive relief in ongoing cases where federal agents seized firearms from wrong people or addresses. Instead of waiting years for cases to work through normal litigation timelines, victims can now seek immediate court orders requiring return of weapons and compensation for ongoing constitutional violations. The federal government's immunity crisis is triggering something unprecedented: state-level rebellion against federal law enforcement overreach. At least 14 states have introduced or are actively preparing legislation creating additional state-level accountability mechanisms for federal agents operating within their borders. These bills vary in approach, but common provisions include requiring federal agencies to notify state authorities before executing raids, subjecting federal agents to state oversight for use of force incidents, and creating state causes of action allowing citizens to sue in state courts under state law, rather than being forced into federal court systems that historically favor federal agencies. This represents a fundamental federalism shift, states asserting sovereignty over law enforcement activities within their borders, even when those activities are conducted by federal agents. Texas has taken the most aggressive stance by introducing legislation that would make it a state crime for federal agents to execute raids without proper verification procedures and state notification. The bill specifically requires agents to present evidence to a state magistrate demonstrating they verified target addresses through at least 2 independent sources before executing warrants. While this legislation will face inevitable constitutional challenges about federal supremacy, it demonstrates how seriously states are taking federal overreach problems. Several states are also creating special compensation funds for victims of wrong address raids, providing immediate financial assistance while federal lawsuits work through courts. These funds recognize a brutal reality. Even when victims eventually win federal cases, litigation takes years and costs enormous amounts in legal fees that many victims simply cannot afford. By providing immediate state compensation, these programs help victims rebuild lives while creating public records of federal misconduct that generate political pressure for reform. Every gun owner in America should be taking concrete steps right now to protect themselves from potential wrong address raids and to maximize their to recover if they become victims. First, document your firearms collection with detailed photographs showing serial numbers, distinctive features, and condition. Store this documentation in multiple secure locations, including cloud storage and physical copies kept off premises, at a trusted friend's home, in a safety deposit box, or with your attorney. If federal agents execute a wrong address raid at your home, this documentation becomes critical evidence for proving what was taken and seeking its return. Without proper documentation, agencies can claim they returned everything, and you'll have no way to prove otherwise. Second, install exterior security cameras with cloud backup at every entry point to your property. This is no longer optional for gun owners wanting to protect themselves from wrong address raids and excessive force claims. Multiple federal cases have been won or lost based entirely on video evidence that either confirmed or contradicted official reports about how raids were conducted. Make sure cameras are motion activated, capture high-quality footage even in low light, and upload recordings to secure cloud storage that cannot be physically seized during a raid. Third, establish a relationship with an attorney specializing in federal civil rights litigation before you need one. This seems like paranoid preparation until you're the victim of a wrong address raid and need immediate legal intervention. These specialized attorneys can file emergency motions for return of property, preservation of evidence, and preliminary injunctions preventing ongoing violations of your rights, but only if they're already familiar with your situation and can act immediately. Having an attorney on retainer, or at least having consulted with one beforehand, can save critical time when minutes matter. This Supreme Court ruling represents just the beginning of what could be a genuine transformation in how federal agencies are forced to treat gun owners and all American citizens. The unanimous 9-0 decision sends an unmistakable signal that even this divided court sees federal immunity protections as having gone too far. But Supreme Court decisions only matter if lower courts implement them properly, and if citizens use the new legal tools the decision created. The next 12 months will be critical. We'll see whether federal agencies actually reform their raid procedures or whether they find creative ways to circumvent the ruling's intent while technically complying with its letter. We'll discover whether lower courts embrace the Supreme Court's narrower interpretation of immunity or whether they find ways to continue dismissing cases on technical grounds. And we'll learn whether victims of past wrong address raids can successfully reopen cases that were previously dismissed, potentially creating a wave of accountability that forces systematic change. Federal agencies are terrified right now precisely because they know how vulnerable their past conduct is to scrutiny under this new legal framework. The question is whether gun owners and civil rights advocates will seize this moment to demand the accountability that's been denied for nearly 8 decades, or whether this opportunity will slip away as public attention moves to other issues. What happens next depends largely on whether victims come forward, whether attorneys take these cases aggressively, and whether the public maintains pressure for genuine reform rather than cosmetic changes. The Supreme Court opened a door. Whether we walk through it is up to us.